this from Ralph regarding the suit from water supply. And all what I wanted to do was get an update and find out what is going on and what is needed for us to make sure that everything is going to be okay for the association. Because as I made mention before, being involved and getting involved with the new board, with Mauna Association, I had no concept or no idea what the left hand was doing with the right hand regarding the suit. Touching bases, yes, a lot, and I'm like Vic, we're going to email a lot, but this, it was the intention of me not to pursue this matter regarding the suit with water supply from the board. And I always said before that has been a problem with a lot of the homeowners. They're feeling that whatever somebody had an issue or problem with, they got to deal with what needs to be done and don't get the rest of the association or the homeowners involved. Okay? And so what I did is I asked Ralph to see if John can come in, and basically no decision is going to be made today. All what I wanted to do was have John Morris come in, give information, so if we got any questions, if I got questions, if you got questions, you can at least ask. No decision is going to be made. Then at least we know what the left hand is doing from the right hand. Then we can decide at the board meeting whether we can move forward, how we're going to approach this, etc., etc. So all I wanted to do is make sure the T's were crossed, the I's were dotted, so that we have a better understanding. And Judy made a mention, yes, we should have gotten, or let me get the homeowners, the other people there, but being a last minute thing, what I wanted to do was get the core of the association together so that we be the people that we can say, okay, this is, somebody comes up to me and says, John, what about this? I couldn't make it. This is what needs to be addressed, and this is how we do it. So the reason I asked that we be here this morning, and I really appreciate you doing this, because it's sometimes, as I made mention, it's a damage you do, damage you don't situation. So what I wanted to do was have John come in, and if you had any questions, especially the new members, because, like I said, we don't want to go and reinvent the wheel again. It's already been moving. This train of suits has already been moving. And from what we understand, I'm not going to say we, from what I understand, there's a lot of people that are homeowners that are very not happy with the way the previous board went with the suit towards water supply on behalf of what other people has done. We really felt we got dragged in, and the cost is that. That's what the biggest thing is too. So I'll make mention that I had to write it down because when you get old, I forget a lot. So I wrote it down and said it's and this is the question for John, if I can get this started. Is it the intention of this president, or it is the intention of me not to pursue this matter, the complaint towards with water supply on this course of action and how it's being approached. I had a meeting already with water supply. I went all the way down there to find out what was going on, and they're very they didn't want to say anything because of course there's a suit that's going on, and I just wanted to find out what needs to be done at this stage, and are there any other options besides the suit?
Okay. Well, with respect to your suit, the suit that was filed on behalf of Mauna, that was filed, I think, in about early December in a very minimal way, and that was primarily, as you may know, there's something called the statute of limitations, which says if you have a claim, particularly for property damage and there's no contractual relationship, you have to bring it within 2 years of when it arose. So the main purpose of the suit that was filed for your association was just to file the complaint. We never actually served the Board of Water Supply. It just kind of sat there to make sure that if in the future you wanted to pursue that claim, you wouldn't have lost it through the statute of limitations. Because my recollection is, and some of you may know better, the damage that occurred happened in about December 2008. So the 2-year statute of limitations would start running from when you guys knew or should have known of the damage, and so that meant that to preserve your rights to bring a claim for damage, you needed to file your complaint to stop the statute of limitations, the limitation on filing. So that's all that happened with your complaint. We did a fairly simple complaint, and we just filed it, and we actually have never served the Board of Water Supply, although it was filed in court. So that's your...
Who filed it in court?
We have to file it in court to stop
the association?
the law firm. Yes. We did it on behalf of you.
They did it on behalf of the association?
Yes.
Request by the previous board.
Yes. And again, that it wasn't served, and the main purpose at that time was to allow the association, if it wanted to bring a, so that if they hadn't filed by December of 2010, 2 years after the damage, then the statute of limitations would say they couldn't file. Now, I think the subsequent investigation indicated your claim was probably $30,000 or $40,000, which may not have made it worthwhile pursuing anyway. But I think that was the main concern of the prior board, that you not lose the right to bring a claim if you had to by letting the 2 years pass. So then after that was filed, we didn't do any more. I think at that time they were looking at hiring the attorney Wayne Sakai, who had quite a lot of experience in dealing with these. I think he represented the towers, and he had some other. So that was investigated, but he didn't really pursue anything, and it just kind of sat there. Now, at the same time, the Board of Water Supply filed their complaint against you guys.
Because we already was with the intention of, they had heard that we were going to file.
I don't know, but that, they didn't serve that on us either. It just sat there. And again, they probably did it for the same reason, the 2-year statute of limitations. If they were going to bring any claims, that was, I think, why they would have filed their complaint. So that complaint just sat there too for, I guess basically 6 months. And then on the 7th of June, Ralph was served with this amended complaint. So the original complaint was filed by the attorneys at Board of Water Supply, and now they've hired the Kobayashi law firm, and they did an amended complaint. They changed some of the allegations. So as you've probably seen that already, there are 3 individual, maybe 4. The Andersons, Bass, and Wiedemeyer are named as individual defendants, and your name as a defendant. The 2 things that would concern you as an association is, the first thing is they are filing for what's called declaratory relief for the court to just make a statement that that drainage system that's on their property, above your property, that there is no official record of that, so they are not bound. They have no obligation to you to maintain that drainage system. That's the first major point in here. So they're asking the court to rule that because there's no written notation on their property that they have an obligation to maintain that for you, that they don't have that obligation. So that's the one claim that affects you. Some of the claims are against the individuals based on the fact that
It affects us because we are...
Well, the problem is if they get the court to rule that, then they will have no obligation to you to maintain that drainage system, which was, again, my understanding when your project was developed, the city required that to be put in, and I don't know, some of you may be familiar. It's basically a system of berms that runs across.
Do we have the records, John, having that? Usually it's in a unilateral agreement. Before something is being approved, there's a unilateral agreement that says before you get this approval, this needs to be done, and you sign it. Is it signed that says that Mauna is the responsible people for maintaining that?
No. But the way it seemed to work.
Oh, I'm sorry, not Mauna. At the time.
Yeah.
At the time, the property owner.
Yeah. At the time, the property owner was Makaha Valley. Right. They owned above you and they owned you. So when you were developed, and again, it's been a while since I looked at it, I don't know if we actually got a copy of that agreement. I think some of the prior board members contacted the engineers of the firm that designed the system of firms. And the way it seems to be is they run across the valley to divert the water around and run it down both sides. So that was, again, I don't know that I have a copy of the type of agreement, but that was the information I believe some of the prior board members got from the company that designed the berm system, and it was a requirement, as I recall, of development, that the city said, before you can develop Mauna, you have to put in a system of berms to make sure that the water won't flood through the property. So the problem was that was done, I think either at the same time or it was done as part of the development, and then subsequent to that, there was a deed conveying that area above you to the Board of Water Supply, to the city on behalf of the Board of Water Supply. So what this complaint is asking the court to rule is that the Board of Water Supply has no obligation to maintain the berm system because there's nothing on the deed or subsequent documents relating to the property that notes that obligation. You know, say if you have a right on someone else's property, usually it's marked on the deed or it's marked on the land court certificate of title.
Right.
So that's the first claim they're making. Then they make claims against the individual defendants about bulldozing the berms and causing the damage to you. But the trouble is their final claim is that negligent property damage. They're saying that from their point of view, the individual defendants who did the bulldozing that caused the damage did it with your approval, because, you know, the way your documents read, you're not supposed to do anything major on your lot without association approval. So the final, this count 3, the last count...
The board, it was approved by the board.
I don't know that it was. That's the whole...
claim.
That's what they're claiming. They're saying because you let these 3 owners do it, you are somehow liable to them for the damage caused to their property. So those are the 2 claims in this complaint. One is to say that they have no obligation to maintain the berm system to protect you, and then the other complaint involving you is that somehow you were involved as an association in letting those 3 or 4 owners do the work which was on Board of Water Supply property, and again, that's an issue in dispute. And so you're somehow responsible as well. So those are the 2 things as an association you have to worry about. The request that the court say they have no obligation to you with respect to the drainage system, which is on their property, and then the other claim is that somehow you were involved in approving the actions by the individuals, so you should be held responsible for that.
John,
the architectural committee.
Yeah. But see, that's where I'm coming from. It's like, I mean, these people went out, and whether they got approval from the architecture committee, and they went out and did something that wasn't abided by the rules or the regulations, then why are we, as the homeowners association, are the ones that is litigation of being part of a suit? Because the same thing, and I make mention again with this, the same way what happened to Makaha Towers, when the rain came down, they tried to blame the Board of Water Supply. They turned around and tried to sue Board of Water Supply, but they ended up losing. They didn't make it. And the only reason why Board of Water Supply went after them again, because the towers went against. The same reason why with this here, Mauna got involved with that, because Mauna was part of the ones that was, because I know because Lee Young went with Frenzel to Board of Water Supply to go out and say they're going to sue. And Lee Young, he did make mention that it was Mauna that was going to be pursuing it also too. Okay, that's what I'm looking at. So
on that one, that's what
Can we
you're
raise our
saying,
hands so we can
and then
get talk?
as far as Frenzel and Young, see, they're not here to say, that's not what we did, or that's what we did. So that's what you're saying. I would have liked to have heard what the other side did or didn't do.
well, that's the whole thing. We never heard the technical person then, Joe. Okay.
My question to you is, you're saying that people went up there and did the work, the board approved them to do the work.
No,
listen
Board
what
of Water Supply.
They're saying to you, I thought it's on the paper. But my question to all of this is, is in documents stating that we own the property, and when did Board of Water Supply take over the property? When was it given to Board of Water Supply? If we're going through all of this here, we should have documents with the land, with the building department, city and county, all of that, where they register the property. Properties was turned over to Board of Water Supply at a period of time. So where is that? I mean, we got to get all of that in the back of us. And you're the lawyer. You know, if you do the research, you should have information on that. Because the property, as far as I know, when I moved in here, was always belonged to Board of Water Supply. And I moved in here about maybe 16 years ago. And was always Board of Supply. So where was it turned over from Mauna owning it? Was it still with Capital Investment?
Well,
and when did Capital Investment give it to Board of Water Supply? So they're taking something, and then now they're telling us that we own the property. And yet, I think a couple months ago, they came out with a paperwork saying that we had a meeting that they wanted to give us all that property, right? They wanted to give us that property so that would eliminate any suit of any kind. So if they wanted to give us that, they have got to know that they own the property. So they wanted to give us the berms.
Well, again, even back in December, the board did not want to spend a lot of money on this at the time. They just wanted to preserve the claim for the 2-year statute of limitation. But the way I understand it, and maybe Landis would be able to, the Makaha Valley Incorporated owned the whole, and then they sold your area to Honfed to develop Mauna. And they owned, of course, the area above your property, which there's a deed in 1987, and it's referred to in the complaint, where Makaha Valley Incorporated conveyed the area we're talking about above you guys to the city and county on behalf of the Board of Water Supply. So
they owned it.
Yeah, so that's the deed, and that's the property that kind of circles, it's above and around.
They want to sue us for something that they own.
Yes.
According to the deed.
Yes. Right? See, part of what they want is just the court to say that they have no obligation to maintain that system of berms that runs above you because it's not noted on their deed. When, generally if there's a limitation, when you sell someone property and there's a limitation on that property, it's usually noted. It says, I'm conveying you this lot subject to these claims. Yes. What they're arguing in the complaint is there's no notation, no mention of this berm system, and no mention that we are obligated to maintain it.
Yeah, but the Board of Water Supply, since they own that property, whether it has a berm there or not, they're still responsible for the water coming into our property. Because that's what he told us several months ago.
That would be that
we are responsible for water going down. But in our community, we have a drainage system, so the water all flows toward the 2 flumes that we have. They don't have that up there. So Board of Water Supply is still responsible for all waters that come from the mountain into our property. Hello?
Yes, but see, they're arguing that they shouldn't be, because if they had that responsibility, it should have been noted on the deed.
It's no responsibility of the berms or anything we're talking about. We're just talking about water flow. Okay? When it rains, like it did.
Yeah.
And they already owned the property at that time.
Yeah, no,
it was turned over.
You're right, Victor. That would be your response to their complaint. That no matter what you're saying there, when you took that property over, there was a berm system, and again, I didn't talk to the engineer, but the engineer apparently told some prior board members the city required that because they were concerned about water running through the development, and so it's supposed to send the water on either side of you and down the... So that would be your response to the complaint, one of your responses.
John, when the board member directed responsibility for this board, when we basically decided not to pursue the lawsuit where we want to establish the legal responsibility of the Board of Water Supply to be responsible. With not pursuing it, we don't create a fact because we leave it open for a future board to go that step. So there is no question of liability or wrongdoing by board members to stop a lawsuit.
The original lawsuit,
the one we filed,
and the reason we filed it is because, and again I'm going to say this again, because people went up who owns the property adjacent to up and did not abide by the rules, and they went up and busted it up a funnel. You say no. I understand what you're saying. No, that's why Mauna got involved. If they didn't bulldoze it all these years, did the water still come down from there? No, never did.
I pretty much initiated the first lawsuit after John sent a memo out that there is a status of limitation is happening, and I talked to Lee and talked to John, and we realized just in order to keep our options open, they can file this lawsuit. Now, when we abandoned that one, the way I can, let me just get on the second stage. When the board abandoned this idea of actively establishing the legal responsibilities of the Board of Water Supply, there is no wrongdoing because we didn't establish a fact and kept it open for future boards to do this step. Now we've got a situation where the Board of Water Supply is trying to establish the legal fact.
Because of what the previous board had did.
No, the Board of Water Supply is trying to establish the legal facts about their obligation towards Mauna State. Now, if we neglect it, aren't we getting ourselves liable towards other members of the association who say you can't just go ahead and let them establish this legal fact?
No, because...
Go ahead. Maybe I can just... there is a dispute whether, and I have no idea, how far and whether the owners who are named here went off their property and did anything to the berm. So it depends on who you talk to, and you've probably heard Al Franzel. So that's something that's a factual thing I don't know. Yeah. I think Landis saw some people, he said they were off their property but what happened is, to be honest, it seems as if the Board of Water Supply was not particularly aware of the berm system until December 2008 when the water came into you guys, and then suddenly they became more aware of it, and that's when they started getting concerned, because the letter that I think some of you saw, the court decisions in Hawaii suggest if you're an upper property owner, you have a right to run your water down the lower guys unless you change something on your property. If you change something on your property, then you lose that right, the automatic right to let your property drain onto a lower property, because if you start screwing around with the drainage on your property, the person below you may have a claim. So when the Board of Water Supply, I think, after 2008, realized this whole big berm system was on the property they received in 1987, then they got worried, because that case law that I cited is pretty clear that if you screw around with the natural topography of your lot, and that creates problems for the guy below you, you have a problem. So when they discovered that, that was one of their concerns, and I think that was the point. They actually offered to subdivide out the area with the berms and convey that to you. But one of the problems with doing that is then you get the liability for maintaining, which is a big issue. And the second problem is your documents say that to add property to your association, you need like 75% of the owners, or some very high. Yeah. So that's what we explained to the Board of Water Supply, that it would be tough for the board to say, yes, we will take on this big liability of maintaining the berms at our expense, and it would be tough for the board to get to 75%. So then it kind of stalled out there.
But John, I understand that, but if the berm was destroyed by a property owner adjacent to the berm, which caused majority of the water in 2008 to come through the property, so whose responsibility is that?
Well,
it never happened all these years except when the big rain came out, and then...
I'm not completely sure, John. There was some photographs that from like I think it was the mid-90s, which showed, it was like a, one of those U.S. government, it showed water had run through your property at that time.
Even in my property in Mauna, before I built, there was an area they told me where I cannot and I should not build because of the natural flow of where the Department of Land and Natural Resources came through. It came out this way. But I could, because mine was at the edge, I could do this, but I couldn't do this. So I understood that part. That was the natural flow.
No, but there was some issue again. I'm not sure because they were trying to save money. I wasn't doing the research, but there was some issue that, and if you go up to the berm above the property where the water apparently came through in 2008, I was told, I haven't been there, that it did not look as if it had been artificially done. It looked as if the water had just breached it before. Trees had gone through, but when you got another big storm, then that's where the water naturally went because it's the weakest point in the berm.
Okay, fix it in. You got to raise your hand.
My understanding, but means obviously the water supply, their lawyers are using a tactic over here. And I think the important part of that one is to get out of their obligation and their responsibility. The question about the cause, somebody actually caused this by some kind of act bulldozing, this is, in my view, more a diversion of that one. Because if somebody did cause it, our first claim would go against the bottom water supply. We can then go ahead and say, yes, but okay, we have to fix it and we have to maintain it, but we can go against another party who is the cause of the damage.
That would probably be the sequence of events, because from your point of view as an association, if the berm system is not functioning, and if it's on Board of Water Supply property, and based on those cases that they inherited it, for better or worse, then your claim would be they have to fix it. That would not preclude them from bringing a claim.
How can see, that's the bottom line again.
Yeah.
How can they fix it if the homeowner went out and destroyed it?
Well, no, then they have a claim. Then they would have a claim against whoever damaged it.
The property owner.
Yes.
Not the association. The property owner.
The association, their simplest claim would be,
We give them the permission.
the Board of Water Supply owns the property, the berm system's on the property, they have to maintain it. So that would be the initial claim, and then the Board of Water Supply would claim against whoever is supposed to have caused the damage. So it would be like a circle or something. We'd claim against them, they'd claim against. So if they were successful, the money would come from that guy to them to fix the thing. And then that would eliminate our claim.
The thing is, all getting back to the deed when it was turned over to Board of Water Supply, the city required a certain maintenance of the property. The city required it.
That's what
The city required.
Yeah.
I mean, they have easements, they have all of this. The city puts in there for electrical, sewer, whatever, right? Okay, the city allowed the Board of Water Supply to do whatever they did with an understanding that these things was in there. Now they came in that they weren't in there. But if you take the documents, they show it all away. When you buy a piece of property, you buy everything that's on the property. And if there's anything to be maintained, whether it is documented or what, it belongs to you. And there's a reason why it's there. So they cannot say that it's nothing in documents. But if you go back into the city, and the city has all the files and everything, and they'll tell them why they have to do it.
Again, Victor, that's exactly what our response.
Sure.
We respond to this complaint. That's exactly what our response would be.
Right.
That the city required this when the property was all owned by Makaha Valley. They required that be put in. It was subsequently conveyed, but it was there, and it becomes the responsibility of whoever.
Right.
So that.
And speaking to that, that's what I was wondering, because usually when you buy property, you do a property inspection. So for them to say, oh, I didn't know a berm was there. I mean, how could they not know a berm system wasn't there?
That is actually, again, Victor's made most of the arguments you would make in response. But one other one is, even though they're citing a law which says for a claim to be effective, for a right to be effective, it has to be noted on the deed. There are exceptions, and one of the exceptions is if you knew or should have known at the time it happened. So, for example, say you're selling someone a property and you and they both knew about something that was going on, but it wasn't noted on the deed. What the court has said is, we're gonna look at the surrounding. We're not just going to look at the deed. If both you guys knew about this and one or other of you didn't put it on the deed, it doesn't mean that there's still not something there. Right. So that's kind of building on what. And the argument we would probably make is the city required this as a condition of development. Then we conveyed that property to them, assuming at their request. I don't know if Makaha Valley was paid or what happened, but and then so they knew it was there, whether it was on the deed or not. It was pretty obvious.
Right.
Yes, so I should work for your law firm.
Yes, well, that's right.
And I only graduated from high school.
Law is not necessarily illogical.
Yeah.
Sometimes it's just common sense.
Since the beginning of the process in 2008, when it was brought to our attention as the board was on the board of the since it's been brought to our attention, I was on the board of that, but I came on board later in March. We know we have all the arguments written out. We've got all of the law written out. We have to wait until the judge makes his decision. That's, I think, where we're at right now. That's where the water supply is finally trying to push it.
I know we can get an answer from the lawyer.
Water supply has a certain set of things that they want to do, and that's why it's going to take John to get them there. We're stalling or kicking the can down the road by having him do the counter lawsuit was basically just to give us that additional time. This is where we are today. To speak about who did something in the past
I understand.
and put any kind of blame on anybody is really totally irrelevant at this point.
I don't think we mentioned anybody on that.
That's what I want to hear, and that's not what I've heard today.
Okay, what I want to find out today, and the bottom line with all of this is, nothing against John Mark, but we have an insurance company that we pay. Why has not and why isn't the insurance company dealing with this that we pay? Now we end up paying way extra money for what John them is doing. I wish, later on I'm going to make mention to Ralph. What had happened, we paid for an insurance, and how come the insurance company is not pursuing? We went out and hired a private attorney or whatever.
Well, he's always been our attorney. He's been our attorney for many years.
But still, we end up paying more. Why have insurance?
Okay, well, so one thing the insurance company won't do is make a claim for you.
Yeah.
That they will defend you, but they will not, even if it might be to their, well, sometimes if it's sort of to their advantage, they might pursue a claim, but generally they will tell you only defense. So that's why we did the initial December one, because they would not do that for you, because that's an affirmative claim against them.
Yeah.
So that was just done to preserve that statute of limitation. Then, as was mentioned, the board decided, for the amount of money involved, it probably wasn't worth it. They also decided, I think, that they didn't want to pursue a claim arguing that, to try and get the judge to rule that the Board of Water Supply had to maintain the berms. Instead, I think there's a letter that I sent just telling the Board of Water Supply, look, this is on your property. We're not going to fix it. You can do what you want, but if something happens again, we will be looking to you to take care of the problem. So I think that's how it was left, because they didn't want to spend the money pursuing. As far as getting the insurance company involved, I think when the complaint was first filed, it was never served on us, but I think Ralph did send it over, at least you have two sets of insurance. Directors and officers insurance, which is mainly if you guys do something, and then liability, which is usually if there's like a claim that you've done something wrong. Right now, I understand from Ralph, the complaint has been sent to your liability carrier. Your D&O carrier said there is no coverage under your directors and officers policy for this type of claim. Now, that might be something we would dispute, but if the liability carrier will come in and defend you, then we wouldn't do anything. And that's why we are actually rarely involved in defending lawsuits for associations, because most of the time they're an insurance company and they always want their own attorney that they deal with all the time.
The biggest complaint that I've heard from a lot of the homeowners is, I understand, the suits, etc. We already knew before 2008 everything what was going on with the CCNRs. Somebody went out and destroyed a piece of property, a berm, which belongs to somebody else. Now, we as an association of homeowners are involved because of what those people did in order for us to make ourselves saying that, we as a community, we end up spending a lot more money for what mistakes or whatever had happened with the property owners with Board of Water Supply. And that has been a concern.
Yeah, but to be honest, John, we did not spend a lot of time on the complaint. That's why you were asking, had we done a lot of... We just did enough to state the basic facts of your claim if you decided to make it and filed it. That's all. We didn't spend a lot of time because that was all the purpose of filing that was.
Okay.
It wasn't...
Joe, and then...
I've seen, just a simple statement, I've been up there in the burn system a couple of times. I walked it with landers. I tried to find out with landers how it is engineered, how it is functioning. Not that I'm an expert on it. But the simple thing is, if it would be just one spot where somebody with a bulldozer went in and it takes to build up that berm again to fix it, the Board of Water Supply wouldn't cry like that. They went into with their engineers and they're absolutely aware that there are multiple spots in the whole system which has filled up with gravel and debris that they have to work the whole system. It's more just the one spot thing, and that's why they're crying, because it costs us that more expensive.
You need to put it back in its original.
It's the maintenance issue. It's a big issue. It's not that what one owner did at one
They never
spot
ever
that
maintain it.
If the people who allegedly did the damage were trespassing, and they were on Board of Water Supply land, how can the association possibly be responsible? Because it's outside Mauna
Yeah, the problem
responsibility.
this is America. Anyone, if you have a colorable claim, you can put it in a complaint and file it. So, again, their argument is because, Jen controlled owners' rights to build on their property, that the board somehow caused this is the claim of negligent property damage, that they somehow caused or authorized or permitted or something like that. Now, whether that can be proven, whether that can be proven, but it doesn't mean they can't allege it. Because the basic facts are, you do have the right to control what people build on their lots, so they're kind of suggesting that because of that, when a member of your association does anything related to construction, somehow you are at fault for not controlling them. But again, what Victor said is, to me, it's a tough argument, I would think, to make, but they put it in there.
What is
You must get in
upsetting?
front of a judge to argue it. Arguing it here is not going to do a thing.
What is upsetting the majority of the homeowners is the fact
Yeah,
that the
I know that.
association
But the whole thing is, the bottom line,
should be
what
the
other people
individual.
don't know,
And it's actually a very
homeowners,
weak case
is
that
that-
the Board of Water have against the association, isn't it? Because we don't have responsibility outside the boundaries of our own
Yes.
estate.
That's what I was trying to explain. There are two basic claims. One is this one, the last part of the complaint, which said somehow you were involved in the process of letting these. But that's relatively minor in a way. The main thing is they are asking the judge to rule that they have no further responsibility to maintain that berm system. That is the thing that probably impacts you much more, because that has a long-term effect. If it becomes like a disclosure item when people sell, and you have some problems because it could affect the values of everyone in the association, because if there's like a potential source of harm to association members, if they're selling their property, they might want to disclose that. So that the negligent property damage where you somehow were involved in these people, that's relatively minor, and as Victor said, I think that could be knocked out pretty easily. But if they are
Couple A. What's it? Property owner? Coralina. Okay, when Stone came in and he bought the property, he bought everything that's in there. And what he did was he says, well, I don't need the lifeguards. But he bought the property and had to have lifeguards because people swim in there. He says, no, I don't need no lifeguards no more. Don't have to put lifeguards inside here. Okay, so he kicked us off the property. He said didn't have to have any security there. So he kicked the security out. So he kicked out two entities that were saving the properties for him. working and making sure nobody gets lawsuits. See? So what happened was he kicked us off. Then he brought the security back. Then he wasn't going to bring us back in there. So we had to take him to the law, and we sued him. We sued him for the balance of 6 months that he owed us. He wasn't going to pay us anything. He says, no, my obligation to you is nothing. I bought this and out. But he's still responsible for the operation of us because we had a contract and signed. And it's just like what's happening with this right here. Although the board of the city and county, like I said earlier, gave it to Board of Water Supply in the deal that they did when they purchased, Board of Water Supply. And it always has been that way. So I know there's records in there to do it. And that argument alone, because they're saying we don't have, and now you're saying, I'm saying we have. So that would be our argument. So as far as the lawsuit from us on them, that would nullify it right there when they're saying that we're responsible. When you give a property, when a person comes in and buys a property, the CCNR states what he can and cannot do on the property. But the CCR, and even us as a board, we don't give the homeowner permission to go on somebody else's property. In our rules right here, in our rules is that even though John is my neighbor, I can't go on his property unless I get his permission. Tori next door to me, I can't go on their property unless I get permission from them. So, I cannot take it upon myself to go in there, damage their property. I'm responsible. And any homeowner that did that in here knows that. And if you go into somebody else's property.
Well, and that would be our response to that one claim.
That's exactly.
Now, so where do we go from here, though? I mean, to respond to this?
Well,
we did all that we could.
Or
no,
can we still do anything or nothing?
Well, part of the problem, unfortunately, is if someone serves you with a complaint, you have 20 days to answer, or they can default you. So there's two things we should probably do. And Ralph was apparently served on the 7th of June, so we should have filed something by...
Which we found out a lot longer after that.
Yeah, I think unfortunately he was away and nobody sent it to you. But so right now, I checked yesterday on the the court website. They have the return of service, which means that whoever signed at Hawaiiana for the complaint, they filed that. There's at least on the court record, there's no record you've been defaulted. But ideally, what would happen is your liability carrier will come in. They will appoint an attorney. That attorney will contact the Kobayashi law firm and say, we will be defending and we would like an extension to answer. That's commonly done. Although 20 days is quite a while, in something like this, it's nothing because there's so many, like Victor said, so many issues. So we should probably try and find out today whether the liability carrier is going to do it. Otherwise, what I would suggest is you at least have me send Kobayashi Law Firm a letter saying, we received the complaint, we've turned it over to the insurance, we haven't received a response yet, we would like an extension of another 2 or 3 weeks to answer. Now, I think one of the things Ralph said is you guys felt like you might be able to work with the Board of Water Supply to do this. The other way you could get is just a continuing extension to allow you to discuss things with them and they won't default you. So that would be where they would just agree, okay, we've served you, we won't take a default, we will be willing to meet with you and see what would happen. Because, the point John made and Victor made about we don't really know what happened back in 1985 or 1987, and we don't have the documentation. We should at least have that to get an idea, because to be honest, I think, Victor's analysis is probably the case. If the city had said to whoever I think Honfed, before you build this development, you have to put these protections on the property above, and then the city subsequently takes a conveyance of that very same property where the protections were put, it's probably a tough argument for them to make that they knew nothing. Because again, I looked at some of the cases, and it is true for your system of property recording, claims against that property should be noted on what's called the certificate of title. But again, one of the exceptions is if the parties involved in this transaction knew or should have known its encumbrance on the property, the fact that it's not on the deed will not necessarily eliminate the claim. But right now, the main thing you want to probably make sure is that you are not defaulted. Now, this, it's only, 27? You're only about 10 days out. You could go to court and get the default set aside under those circumstances, almost certainly, because judges don't like to see cases decided just by default. So that would be, but probably to avoid that extra complication, I'll check with Ralph if we've heard back from the liability carrier. If they're going to do something, no need for me to do it, but otherwise I should probably at least send a letter to the Kobayashi law firm saying, we got this, we turned it over to the insurance carrier, we're waiting, we'd like an extension to answer. So, as of yesterday, on the court record, they had not filed the default, but they had filed notice that we were served on the 7th, which means they may be, I think they themselves would realize, even if they file it, the judge is not going to let a case like this be done through default under those circumstances.
I think at this point of the game that's going on right now, that would be, I sit on the board, my recommendation to you as the lawyer, that even though eventually you're going to either represent us or the insurance is going to represent, to find out if this thing is getting done. If not, then by all means, we pay you and have you go file the papers so that we know that it's filed, and if we're not going to lose out on anything for our side.
Well, I think the main thing we need to get, really, Victor, is just an extension.
Yeah.
Because if you get an extension, your liability carrier comes in.
We don't have nothing.
Well, that's all we
so
need
why
to
wait
do.
and wait to Ralph?
We can't make a vote. We can't make a vote on it. But if we can have a consensus of, agree that that's the situation that we should do.
Well, you have nothing to.
All I want to do is just. That's the reason why we wanted to get everybody together. So that is everybody okay?
Yeah.
Then I can go straight to Ralph and straight to John and just from there.
Yeah. I think all that's here. You take a vote right now.
It's only a letter.
We're not taking a vote.
Whatever.
It would only be a letter. It would just be a letter
Yeah.
saying,
No cost.
we were served. We're waiting to hear from the insurance company. We'd like an extension.
You got anything, Sandy?
Yeah. That's the reason why I wanted everybody together so that we can have a consensus and to see if that's the situation we're going to go through. And then I don't want to just go ahead and say, okay, let's go ahead and do it, and then we don't have any part of. Again, I'll say we can agree to disagree. Because I'm very upset that even we're at this stage already. And it's my opinion though, when I felt that we should not have been from day one, because
it's been taken care of
long time. But pardon? That's the whole thing. We're being part of paying for the damage. It should be the person who utilized or jeopardized the process of went in and bulldozed something and did something bad. It's almost like me going down and bulldozing something and it affected the next door neighbor down below.
Sure.
So that I'm responsible, right? Then they should deal with me. Right. Don't go to the association and have the association pay you. But end up from more money. I understand that.
That's not why their law firm or the Board of Water Supply is suing us. The Board of Water Supply is suing us because they don't want to care for the firm.
Well, the Board of Water Supply is suing us because we went out and...
That's not what it is.
Yeah.
They own the firm. That's their property.
They don't have any liability.
No, that's their property.
I understand what you're saying. I understand what you're saying. But that didn't happen until we went forward and bulldozed the area, and that became a problem. But anyway,
the sequence was the Board of Water Supply filed earlier than we did. We filed after the Board of Water Supply. So our file against the Board of Water Supply is still with them to file against us. But
regardless,
default, by default, basically,
they never filed.
The legal status, whatever.
You can ask the lawyer.
If they default you, that will mean that you have not contested any of the allegations in their complaint. It's just that if you are defaulted, if you don't respond within the 20 days, then they have an argument that everything they alleged in their complaint was true. So that's why you don't want that to happen. No matter what else you decide to do, you do not want to be defaulted on this complaint, because a lot of the issues there have, as I said, continuing implications.
When you file that thing, you have to answer yes or no. If you don't, then you think I'm guilty.
The first step right now is get an extension of
Yes, and that's just a letter.
The next step would be that basically somebody send them a letter that we don't agree with your allegation.
No, we would have to file it, well,
Radio got to do it.
you would have to file an answer. You would say, as to this allegation, we dispute it. As to this like if they say you're an association in Makaha Valley, you don't dispute that because that's true. But if they say you were responsible for allowing the 4 owners to go onto their property, then we say no, that's not.
See, that's the thing that.
But you cannot do nothing until all of this gets done.
The Board of Water Supply to us first.
Yes.
Because why?
Because we had a claim against them.
Because there was
And
a
then we had time
claim.
to countersue.
We had a claim against them.
Yeah.
The board of
You know all of this, right? You can explain to them who filed, what filed, and why we filed.
without the party
Regardless of who.
and having no obligation to maintain it.
Yeah. To be honest, John, I think what bothered them is when the board decided they weren't going to try and sue your board.
That's when Water Supply decided to go ahead and
when
sue.
we told them, look, we aren't going to sue you to make you fix this, but if anything happens, it's on that letter that I sent. If anything happens, you will be responsible. And that's why they want the court to say, no, if anything happens, we're not responsible. So I think that's why they got the Kobayashi law firm involved.
We simply put them on
And it put
That's what it is.
So you basically
It's like I call you a name, you call me a name, and it's
take that allegation up and answer it, then it would go to a judge. Then is there mediation, most likely?
Well, they probably would. Judges often do try. I mean, the first thing, as John and Victor said, is there would be discovery. We would ask for discovery on all the circumstances surrounding the creation of Mauna and the deeding of the property above you to the Board of Water Supply, because there's probably, like you said, there'd be some kind of city and county official zoning change. There would probably be things by the Department of Public Works saying this should be done, that berm. So that's what we would probably do. When you get all that information in, that's why 95% of cases settle, because when you get all the information that would be available, then, say your insurance defense attorney would say, we have to settle on this, but they will have to do this, and that's what happens.
I think, basically, if you look at the whole picture, that what they're trying to implement this, implement that, and going back and forth, and just to see what's going on. But the problem that I see is simple. I mean, we can't do anything, but you did what we did, and they did the filing and all that, so we need the time. And then now with this other filing that they sent, we got 20 days to respond, so we need to get that going across. But the first thing we're going to do, that all has to be done.
Consensus with that. Yeah.
Well, the first thing is to get an extension.
And then also with the Board of Water Supply, from the time that you receive the property, in there should have something in there that has where they're supposed to maintain. Because if you don't maintain, all the water and flood and silt comes down to the berms that never went over, now it's built up. If it's supposed to be 60 feet down, there's not 60 feet no more. It's only like maybe 10 feet.
Yeah, that needs to be
what we
found
need
out.
to do is the law office or the insurance needs to know, and I think is how often the Board of Water Supply is needed to clean the property. And I think as long as I lived in here, they haven't done that at all. And it might have not been done for the last 30 years.
Because we need
all
to
of a
get
sudden,
the paperwork.
Wait, I got the floor.
No, we understand we're talking, but we need to go out and find out the rules and regulations on that.
No,
this is just assumptions.
We explain it to the lawyer, and he has an idea of what we're talking about.
I
don't like this kind of meeting. They just cut me off.
Go ahead and get civil engineers involved in whatever. My take on this issue is basically we're not there to tell the Board of Water Supply how to do it. We're just there to tell them they have to make sure that the water doesn't.
Nobody's telling them how.
Again, the main thing you want to do is, number one, don't get defaulted, so I'll just send a letter.
That's all, the first one.
Then number two, you hope your liability carrier will come in, because no sense you paying for something like John said that you've paid for years for your insurance. You should be able to.
That's right.
So that would be the second step. If for some reason they will not cover, your D&O has said they won't, you may have to get someone who specializes in insurance just to look at your policies to try and enforce them. Because the trouble with insurance is when you make a claim, their first response often is, but I've seen cases where associations have been turned down. They hire someone who specializes in insurance policies, who then goes into a negotiation with the company and says, look, this is here, you cannot say that. So that might be something, but don't worry about that now, because you don't know. If your liability carrier will come in, then that's okay.
Do you know if the liability insurance company has ever been contacted, ever?
No.
I'm not sure what was done. When we were never served with the original complaint in December, but we checked the records and found it, and I think it was sent then, and I honestly don't know.
Was sent to the directors and officers?
We usually just send it. I know it went to your D&O, and they turned it down back then. I don't know if it went to your liability directors and officers. So one is insurance for, probably the difference would be like if you're supposed to have told people they could go on the property and do this, that might be a D&O claim, I'm not sure. Whereas if it's just a claim that you've caused damage, that's probably a negligence, that's more likely to be liability.
Okay,
but I have to admit that the way in which insurance companies divide it, I really don't know.
The liability insurance company, were they ever contacted?
They have been now, yes.
Oh, okay.
They have been. So that's what you hope your extension would give you time, and then they'll come in, they'll contact the Board of Water Supply Law. Sorry, Sandy.
Joe, in fact, since you were on the board when this happened, you say that the liability insurance has been contacted.
At this time,
this time. Were they contacted way back then when it happened?
When Ralph went ahead and contacted definitely the DNO when we were working in the before that. It is about the lawsuit. So when there was this filing in December, Ralph contacted definitely DNO, and they denied coverage, and the letter went to the board to deny it.
Okay, but when it happened, when the damage happened, was it filed?
When the damage happened, we actually started to contact FEMA because it was a national disaster, and then we had. But I don't know if they followed through with the whole thing because management company got changed and whatever, and. The damage which occurred to our property, to my knowledge, wasn't anything that had to do with insurance.
What was that? You mean you contacted FEMA, but you didn't contact our insurance, or did the...
I think they did contact our insurance.
No, they didn't.
This time I wouldn't even know under which insurance.
You got a response from only one.
Somebody has to know, right? Somebody on the board has to know. And also, did the board at that time advise the homeowners with the damage to contact their insurance company to file a claim? Or at least to let somebody know they had a damage?
What went into this becomes a little bit too much about what the old board did and didn't do.
But you were on the board.
That's why we're here.
I wasn't on. No, we're not here. We are here to listen to John Morris.
No, but we need, this board needs to know how, nobody
we don't know why
ever told us anything.
we're trying to find out why we're here today, and that's the reason.
The reason we are here today, we were filed by the Board of
and the reason we were filed by the Board of Water Supply, Sandy had made mention there were things that were done prior to that also too. That's what we're trying to figure out what was going on.
Okay, so I'll just assume that the board contacted FEMA, not our person, not our association insurance, and the homeowner. But there's
no record.
Going to get answers from?
There's no record.
You might want to go back to Chantel because
you
might want to go back to Chantel.
You can. I think you had the same insurance agent at least, so she would probably have a record. The problem with large floods and things is sometimes they are excluded or they're covered, but they have a very high deductible. My understanding of the damage when we were doing a rough estimate for the complaint was it was 30 or 40,000. So it's more than possible that was turned over to them, and they either said this is like a act of God.
Sure, I understand.
They said this is, you have coverage for this, but your deductible's $50,000.
Sure.
So that may But I think you had the same agent, so she might have a record. I can ask her.
Okay, when you say she, who's she?
No, I
insurance
thought I thought your agent was Sue Savio, but I'm not sure.
And what's
we
the
gotta
name
find
of
from
the insurance
Ralph,
company?
Ralph would know who you are.
What's the name of the
And if he
insurance
did send a
company?
paper,
Well, Ralph would know. I thought your agent was this woman, Sue Savio, who's Insurance Associates, but I'd have to ask
Is
Ralph.
this the same insurance agency that just dropped us? Because we have a new insurance now, don't we? Yes, we do. And would they cover us on something that happened so long ago?
Probably.
They dropped us because of this.
No, your company might drop you. Generally, your agent would not unless she felt you were just... So it may be that your company, your prior company dropped you, but you may have the same agent. Because your agent, unless you have a company-affiliated agent, your agent will usually try and shop around and get you the best deal. Or if you're dropped, she will find you or he will find you another company.
yeah, but even if the insurance company now,
Yeah.
it doesn't make any difference because we pay them up to that point to cover whatever we were involved in.
Yeah.
So they're still liable for the involvement
They
because
should-
they accepted the money and, you
Yeah,
know,
they should be
because they
if the claim,
changed.
if the
Yeah, they
claim
still have the
made
insurance.
during their policy.
The Board of Water Supply, had Kobayashi take over.
I think what happened is, if you read this series of correspondence, they thought that it was all pretty straightforward and that they were in control. I sent them a letter, the one Victor, saying, look, there's Hawaii case law saying that if you change the drainage or if you're the successor in title to somebody who changed, and I think that's probably when they got worried because in their original complaint, they were not asking for a ruling that they were not responsible for the berms. That's what I recall. So I think that's probably, they probably realized that, and that's probably why they went out to outside. And Kobayashi is actually one of the bigger firms, so they must be paying a fair bit for this, I would think.
That's why they wanted to give us the berm system up there.
Yeah, see, they did offer to subdivide that area out and
give it.
But we explained to them, number one, it's a big liability. Number two, you need 75%, which I don't think
No
you're
way.
going to get.
Do you have any idea, like, if they were to go ahead and keep maintaining it, how much it would cost them to...
Well, I don't,
because they
it's a
charge
big
us
system,
for
but
the water, I mean,
yeah. I think it would be a matter of probably cutting. I mean, from what I recall before, cutting and, like Vic said, they'd have to just bulldoze behind the berm to put that deepness back in, which has been gradually filled up.
all
with
the
silt.
trees that is growing.
Yeah, see, the trees, I think,
like,
are also...
about how much would that potentially
to be honest, Matt, I've never been up there to even see it.
No, I mean, because they charge us for water and stuff like that, so it's not
No,
like...
it should be one of their expenses
it's not like
of doing
out
this.
of their own
'Cause I
pocket.
think one of the reasons they took that property is they take a lot of water out of it.
DLNR bought a water supply to us. So, everybody's going to start pointing fingers. The same with, again, I'm going to make as a form of experience when I went to Mauna Towers. The waterfalls, they blame water supply because the water came from DLNR into water supply's ditch. The homeowners there, the towers, try to charge or sue water supply because the water went over the ditch, which the ditch could not accommodate that much water coming down anyway. So did they win? Did the towers win? No.
But John,
No, but what?
what I heard is that what towers actually signed an agreement with the Board of Water Supply that they will maintain the berm.
Well, they should sue the board then.
But then they should sue the board.
Yeah,
But that's it didn't work out.
It isn't, well, I think what you're saying is true. Many people think, like the fact that you have a hillside and a boulder rolls down and hits somebody's house doesn't make you liable. A lot of people thought that, but as long as you didn't do anything, as long as your hillside is in its natural state, the basic legal principle is if you build at the bottom of the hillside,
This is where water supply is going, and they're using that technique.
they are doing the similar
But
thing.
because the same thing that way, but it didn't happen, but somebody went and bulldozed that area. Okay, that's what they did, and that's what they're trying to
I
do.
think that's the Board of Water Supply's ammunition. There are people up here
Exactly.
that make that claim
But
without proof.
But you see, Frank, that's when the property owner should deal with the Board of Water Supply. And he's going to explain himself. But anyway, so explain that.
No, I mean, I think that your main concern as an association is just about the maintenance of the berm. The Board of Water, you would have the...
Mine is not the maintenance of the berm. The berm was destroyed by a property owner. Bottom line. That never had happened prior to that. For all the years it's been up here, yes, they had this concern. They had the rivers running through, and they're blaming because the reason the flooding was happening is because of everybody down below didn't do their job of cleaning up, etc. But if you open up a funnel area where, or berm, a dam, to let it leak through, guess what? It's coming in, and that's what's happening. Before that berm was open, everything was fine. Everything was fine. Yeah. That's the bottom line with me. Yes, how do we go about doing this? It seems like we're trying to go out and rescue property owners that went out and did not abide by the architectural committee, by giving this. They should have known this and that. But we all are the ones that obtained and taking the cost. So, but the simple...
Was that a proven fact, whoever these owners are that went and... proven, was that a proven fact?
I think that's what Frank is saying. There's some dispute. For example...
There's always going to be that.
I forget, one of them, Mr. Bass, something, he had some work. He had a pile of stuff on his lot, but it wasn't part of the berm system. It was just left over from the development, and he, I think, did remove that. And that, there's some argument, this is just what I recall from before, there was some argument that removing that pile of leftover on his lot had nothing to do with the berms because it was on his lot. But I think the problem is nobody is completely, on the ground. It's hard to tell where you guys' property ends and the Board of Water Supply, because the line is not straight across, it goes up. And
usually you have a survey of your land.
That has,
And within that survey, it shows, where you can look, the picture, it shows that within that line of the property owned, there was encroachment in across.
And witnesses.
What you're saying, I absolutely agree on. I absolutely agree that we should not fight for what an owner did right or wrong. That is his own problem, and he should work that out with the Board of Water Supply. And we shouldn't get involved in that one. We shouldn't get involved in the whole argument. What matters to us is we can argue, and I think truly we never gave any owner a permit to do anything on the Board of Water Supply land.
Yeah, we know that.
We all know that. And that the association feels like that the Board of Water Supply is obligated to maintain the berm system. That's all we want.
But it wasn't the cause of this whole situation where we're at today.
But John,
it was the destroying of the berm system.
You've already made the case to the other side. By continuing to say what you're saying, you've already made the case to the other side.
Do you understand it?
I understand.
Well, then
you've already made the case.
It should be enough already. Let the lawyer take care of what he needs to.
Somebody did the damage, and so therefore the Board of Water Supply has no claim.
They're in the library. They have other parties.
Yes, they named the other four.
Then that's what I'm saying. Then let it go. We should not have been involved.
That may be the case.
That's what I'm saying. If you went out and you put a 3-story tower in your place, simple, then you're the one that's in violation.
Yeah, they're simple. They have the other people named right here in the suit.
I know.
They have it. That's in the suit.
I know.
But that's why, with this legal problem we have, that's why we're going to have John to go out and continue to pursue that. Okay.
It's all we're here for.
But I want to find out, why are we here? What caused us to be here?
John,
You know it already.
John,
I know, but still yet, what I'm trying to say,
You keep getting the same answer.
the same answers is,
You
the
brought
same answers
to me the
is,
answers. That's why we're asking
doing the same
questions.
thing over and over again, expecting a different result.
Okay.
It's insanity.
Okay.
You keep asking the same
the
question.
next board,
told you.
Frank, the
And
next
you
board,
know it.
the next board when we're done, the next board that comes over, if they ask the same question, please come by and you tell them the same thing again. Okay? If they have a concern, if they have a question,
I am on your side. Don't you understand?
I understand.
You're arguing your
The frustration.
You guys are arguing it.
Go ahead, Joe.
we are sitting here because in 2008 our streets were flooded and we realized
Because some idiot went out and bulldozed the property. Bottom line.
and we realized there is a bond system above and realized it has to be maintained by the Board of
No,
Water Supply.
it was
And the
maintained. No,
Board of Water
no.
Supply
That's
here-
where I disagree.
John,
Sorry.
John, you can disagree, but at least listen to me. And the Board of Water Supply...
I have listened to you, Joe. That's the frustration part, too. You keep on going back and forth, and I'm telling you the bottom line. And I understand your situation. I understand it.
What is my situation?
Your situation is you protecting what had happened in the past. This is the way it's abided by. And the same with Frank. I understand. We all agree. But we go back again. The Board of Water Supply should have maintained it. Wait a minute. It's not Board of Water Supply we're talking about.
Got some kind of conspiracy theory here about the last water. That's what it is.
Conspiracy?
Of what?
Well, I think
Nobody knew what was going on.
I think the whole fault is
I'm sorry.
that when they filed, and then the file was back on
Not about the Board of Water
our
Supply.
association.
It's the Board of Water
People
Supply
went
who's
down.
suing us.
No kidding, because what we did.
Individually.
We didn't do nothing. I didn't do anything.
No, the property owner that we're protecting.
That's what happened.
I'm not protecting you.
Yes, we
The other
have.
two guys that went down.
We young them went out and
Yeah, yeah.
protected.
Exactly what he's saying.
Frenzel then. The bottom line, back to them. They're blaming water supply because of the water coming into the property that went into our streets of Mauna.
Let's fuck the whole thing
but
right.
it did seem to be...
I understand. That's where I'm coming from.
He's going to tell what I'm saying.
No, I think the main thing you just have to really focus on is not getting defaulted, seeing if you can
Yes,
get
John.
There you go.
That's the bottom line.
Let's do that and
Yeah,
let John go.
yeah.
We can beef it out later.
Yeah.
So I think that then if that's okay, I'll just send a letter over, ask for an extension.
Yeah, something like this.
I'll ask Ralph to check the insurance records and find out.
Then if the insurance company has not done nothing at all, and there's no filing by them, but by all means, it's got to be all filed by you.
Yeah, we may just do an answer.
Yeah.
And then once we do the answer, then that's when all the process of discovery.
Right.
So we just, if they'll give us an extension, then we'll wait.
We have no choice, but
Yeah.
it would be you because you're familiar with everything
Yeah.
that's going
But
on.
what we're gonna do
So
too?
we need to know
Right,
that
we're gonna work. We're gonna work with Ralph. I'm gonna call Ralph, ask him for all the records of whatever is available from the CCNR, not CCNR, but the unilateral agreements before Hunter bought it.
And even if the
You know,
insurance
etc.
has changed,
And
it's still liable.
they have water supply. About a telephone with all those records.
It should be.
And then that way we can just at least
you look at picture this morning, if you don't
and
know
how this future, with this present board, follow up.
Are you aware that the firm,
Yeah?
and if the firm fills up with silt, what happens to the water?
The silt, the firm has to be granted by the owner.
If the berm fills up with silt, water comes over the berm and it goes wherever it wants to go, correct?
It's the property owner's fault.
So
Responsibility, I mean.
would you agree that that was what happened?
No,
No.
that's not what happened.
Okay, well that's where...
Yeah, because all the years I used to go hunt up in that area before when
Well,
they
I'm going to tell you something, Lucchini, right now. I was working on the property, which is Kazu's property. I seen a dozer back inside that area. He went down over the hill, and he went down. I seen a dozer. You know what the guy, I didn't see him pushing anything, but he went over the dam, over the berm or whatever was back there, off the property. He had to go over it. He went down. You know what he was doing? His blade was facing toward the berm. He was eating lunch. So I continued with my work. Was doing. I didn't go up there and look what he was doing. It was none of my business because that was on a different property. That property he was on, I can tell you he was on Board of Water Supply property. Because he went over the berm and he went down in the bottom. not the bottom, but he was over where I could see him.
What harm did he cause?
He went over the ditch, over that berm. He's made the swell go down, guaranteed.
Okay.
You know how heavy one of them dozers are? You're talking tonnage, 70, 80 tons. When you walk over one piece of dirt, what happens to that? It folds in. Now, if there's debris that's all filled up over here on the other side, when the water comes down there for 45 days or whatever the water was, builds up, where does the water go? The simplest place is going to go on the berm, on the tracks that was made.
The lowest part.
The lowest point.
That one went
That's all it takes, one event.
supposedly over. That's what caused all this.
Hello?
That's what you eventually hope will be determined.
Because where did the water come from? From that spot? From that area? That's where they broke through?
But, okay, we know. We're going to be here all morning and stuff. But John's going to go and do that. I'll follow up with Ralph. I'm going to make sure we get all the records of all the agreements that were made in the past. And then at the next board meeting, we can bring it out and for discussion, you know, for new business, we can bring that out and have talk about it. And that's what.
If the liability insurance actually says, okay, we're taking on this suit, does the board want them to do?
If the liability means that's something we need to discuss.
Yeah, it's just that we're operating on a tight deadline here.
Well, that's the whole thing.
We're hoping if they won't give us an extension, we would probably just do a very simple answer for you and just file it. And then we'd have to research and do a better one later. But they should give us an extension. In Honolulu, in Hawaii, there's not too many hardcore people who would just say tough luck.
And you know what's really funny? Because last week, not last week, but the week before, I went down to the talk with this guy Tracy from Border Water Supply, just to introduce myself as the president.
And who's Tracy?
Tracy works for the Border Water Supply.
I know, but what is?
He is with the issues that we're dealing with suits, etc., and whose fault it is. But when I discussed with him and I told him that, you know, I'm hoping that this board, not the previous, this board is not going to pursue a suit towards Border Water Supply for the maintenance and stuff. And he went, wow. It was almost like the reason they're doing all of this because the previous board, when say, you know, you're not going to go ahead and do this, this is what we're going to do. And so what they did, they started to say, okay, let's get ready, here they come. So before they do this, we're going to go ahead and do this, go and do this. But when I went inside, I said, hey, you know something, we understand, but I don't think we want to go ahead as a homeowner. We don't want to pursue the association. You can deal with the homeowners that had messed up with the other three, but Mauna Olo, for my, you know, thing, I just want to just get out of there. It shouldn't be us that's involved in that. It should have been, you know, the homeowners with Border Water Supply. And when they looked at me, they went, whoa. Not saying that it's going to stop, but they were like, okay, we understand better. You know, so, but that was just my opinion, and because they asked me what did I think, and I tell it like it is, and I told them what I thought, that we shouldn't be, Mauna Olo should not be involved in that.
Simple because we didn't give the individual permission to go over the berm or go in somebody else's property.
Yeah, but
when you buy a piece of property, it's pegged out. It tells you pin to pin where you can and cannot work. If you cross the pin and go over, then you're in somebody else's property. I got property on the Big Island, and if somebody goes on my property and they build a house, that house belongs to me because they're not supposed to build on there. It's my property, right? Okay, I can scream, cry.
First thing, everybody agrees. Thank you very much.